Hello, everyone. Welcome back to the LAOT podcast. I'm Arnav Mathur, and today's conversation brings into the question the relationship between man's best friend and public law. What does the Constitution owe to animals? When a court steps into a domain that is simultaneously governed by statute, contested by science, and freighted with moral disagreement, where does its legitimate authority end? And what happens when a judicial order, which is issued in the name of protecting human life, becomes politically weaponized in ways that may directly contradict its own terms? So here's what has happened so far. On May 19th, the Supreme Court delivered its final judgment in the suo motu proceedings titled In Re City Hounded by Strays, Kids Pay the Price. Now, this case began with a newspaper headline about a child's death, expanded into pan India constitutional intervention, and has now ended with a ruling that effectively permits euthanasia of some stray dogs. It transfers monitoring responsibility to every high court and contains a rather unique institutional experiment, one that involves today's guest directly. To help us think through all of this, we are joined by Vivek Mukherjee. Vivek is an assistant professor at NALSAR and the faculty coordinator of the Animal Law Center. He completed his undergraduate studies at NLIU Bhopal and holds an LLM from NLSIU Bangalore. Now, the Animal Law Center was set up in 2016 at NALSAR in collaboration with the Humane Society International India, and it has been doing sustained work at the intersection of law and animal welfare. Vivek, thank you so much for joining us today.
Most welcome, Arnav. Dare I add a PhD from NALSAR recently?
Yes.
Right. Thanks, Arnav. So uh, before I can get into the exposition of what has really happened,
Yeah.
I must say that this is an issue that was knocking on our doors, and we had no choice but to intervene
Yeah.
in the Supreme Court because it was about our dogs, and our dogs were to be picked up and not to be returned back to us. So
Yeah.
it was, in a way, really, really immediate, if I may say so.
Understood. And I think the chronology of this case is extremely important context for everything that we'll discuss today. The intervention was sort of an accumulation of several orders passed across a year. Each one of them was either walking back the other, building on the last. So, can you explain to our listeners the entire arc of this particular case? What I want to understand particularly is what was the court's understanding and how has its position changed across all these orders?
Right, surely. So before I get into the arc, I
Yeah,
want to flag something at the outset because I think the shape of the litigation itself is the story.
yeah,
Uh, this is a case that started with a newspaper headline, as we know, and
yeah,
expanded into a pan India intervention.
yeah.
Along the way, the court itself changed its mind
Hmm,
twice before arriving at the May 19th judgment.
hmm,
So, when we look at the four orders together,
hmm,
what we are really looking at is the court's reason is that the court is reasoning out loud in public about a problem that it picked up on its own. So
hmm,
let me walk you through them. The
yeah,
first order is August 11, 2025. A bench of the Supreme Court having read a news article titled "City Hounded by Strays, Kids Pay Price."
yeah,
Really alarming, if you ask me.
hmm,
The headline itself about the death of a 6-year-old girl in Delhi from rabies
hmm,
took suo motu cognizance and issued what was effectively an order which said round them all up
hmm,
in the NCR region.
hmm,
So every stray dog in NCR was to be picked up, placed in shelters, and never to be released back. Now we
hmm.
we all know what the fate of a dog in a shelter really is,
Yeah,
not just in India but around the world. It's like a death sentence.
yeah,
Now the reasoning that the bench leaned on, and this is really surprising because because it kind of goes back to a couple of years and relies on the 2023 Jallikattu judgment,
Hmm.
where the constitutional bench had said, in essence, that animals do not possess fundamental rights, and it is the legislature which should decide whether they have rights or not. But until then, they don't.
Hmm.
And once that proposition is on the table, the logic of the August 11 order becomes very easy to construct.
Yeah.
You have a fundamental right to life under Article 21, which is exclusive for humans because it says persons, and for
Yeah.
all practical purposes, persons means humans, unless the court says otherwise. You have no constitutional standing on the other side of the ledger for animals. And
Hmm.
so the question collapses into a zero sum, which is human rights of humans
Yeah.
versus an empty space, nothing, nada, right? It's you
Yeah.
put animals there, you put whatever, it doesn't exist. So
Hmm.
that's the chillingly direct logic of the first one.
Hmm.
Moving to the second order, just 11 days later, which is
Hmm.
August 22nd,
Yeah.
was a course correction and was a ray of hope for us. But in those 10 days, we see a lot of cruelty happening across the country.
Hmm.
So
Hmm.
this was a three-judge bench headed by Justice Vikram Nath, and it walks the first order back. Literally walks the first order back. It uses a very striking phrase in the judgment. Uh, it says a blanket pickup order would create what they call as a catch 22 situation, because, and this is really important because this is exactly what we rely on in our impleadment,
Hmm.
because there isn't enough shelter infrastructure to accommodate Delhi's stray dog population, let alone NCRs, let alone the countries.
Correct.
Right? So sterilize and release is reaffirmed in this order, in this
Hmm.
August 22nd. The ABC rules 2023 is restored to its normal operation, and
Correct.
this is the moment that gave us a lot of hope in the animal liberation community.
Yeah.
So, although albeit like cautious hope,
Hmm.
but it was hope nevertheless.
Yeah.
And literally, you see the court stepping back from the brink. It had recognized that a directive issued without infrastructure to back it up doesn't help anybody, not
Yeah.
dogs, not humans. It just produces a different kind of cruelty. We saw
Hmm.
literal cruelty on the street,
Yeah.
and there is a very clear distribution problem of infrastructure in this whole thing. The
Correct.
third order, which is the November 7 order 2025, is where the present arc really begins. This
Yeah.
is where the court, and this is so typical of the Supreme Court since the last so many years, and I teach environmental law.
Yeah.
Think Godavarman, for example.
Hmm.
This is where the court, instead of dealing with the NCR alone, expands
Hmm.
the canvas to the entire country. But
Hmm.
at the same time, while it expands its scope in terms of its reach, it
Hmm.
narrows the spaces it is regulating. It
Hmm.
and comes up with a unique kind of uh, a category which is institutional areas. Now,
Hmm.
these institutional areas are education institutions,
Yeah.
hospitals, sports complexes, bus depots, railway stations, etc.
Hmm.
And it issues what is effectively a partial revival of the August 11 logic for
Yeah.
those spaces alone, and says that every stray dog inside them must be removed, sterilized, vaccinated, but not, put
Released.
in the same place,
Yeah.
right? Not re-released to the same location. So
Hmm.
rule 1119 of the ABC rules,
Hmm.
which mandates release, is being switched off,
Yeah.
but only for these specific premises.
Hmm.
Two things to notice about the November 7 order.
Hmm.
Firstly, the legal architecture changes here. The court is no longer relying on the 2023 Jallikattu logic, where the
Hmm.
court recognized that animals do not have rights. If they are to be given rights, you have to go to the parliament.
Yeah.
It does not engage with that. It is rather relying on something else, which is very, very intriguing and also, like, in a way, raises suspicion as to why they are doing it. It
Hmm.
relies on Article 142. which
Yes.
talks about complete justice, right,
Yeah.
of the Indian Constitution. So, within, and the second point that I want to highlight about the November 7th order is that within
Mm,
days of the order, the public reception of it doesn't, track the legal text. They don't
mm,
care. The public reads newspapers, it doesn't read judgments and orders, right?
yeah.
Legal text is very clear. It is saying remove shelter, do not re release for these
Mm,
institutions. The on the ground reception, however, in many municipalities and from many citizens reads that the court has said dogs are the problem, do what you like. We
correct.
see spike in poisoning, beating, unlawful culling after both
Mm,
the August 11 and November 17 orders.
correct.
So even at this stage, before the May 19 judgment, a
Mm,
worrying pattern has become visible that even a carefully worded judicial direction, once
yeah.
it does this political and media jungle and madness, or you can
Mm,
also call it ecosystem, can
yeah.
get translated into something the court did not ever say. Now, the
Mm,
question is, was the court ignorant about the chilling effect of its own orders? Uh,
mm,
and how do we think about the court's accountability in these cases? The
correct.
final limb of this whole arc is the May 19th judgment, which we
Yeah.
are here to discuss. The court does five things here. It dismisses all the modifications and recalls application. It
Mm,
upholds the no release direction for institutional areas. It
yeah.
shockingly introduces for the first time ever a euthanasia direction
Mm,
for rabid, incurably ill, or demonstrably dangerous dogs. It
yeah.
mandates that every district must establish a fully operational ABC center, and it builds in an accountability architecture for implementation and im- gives certain immunities from FIRs for people who are doing this, while
Yeah.
requiring any institution that wishes to, like NALSAR, for example,
Mm,
which wants to continue caring for campus dogs to file an undertaking accepting tortious liability.
correct.
NALSAR is nested within all of this, where the court permits the Animal Law Center to continue its CSVR, capture, sterilize, vaccinate, release program inside the campus on a
Yeah.
so-called experimental basis. Right. So this is
Correct.
where we are. Uh, I think the most important way to read these four orders together is not as four separate decisions, but as a
Mm,
single sustained engagement in which the court is visibly reasoning under pressure. And
yeah.
the pressure is from news reports, from
Mm,
competing constitutional values, from operational impossibility, which we highlighted, and from
yeah.
all interveners, right? And
Correct.
this reminds me of Cass Sunstein, who makes a very important observation about courts under conditions of moral and empirical uncertainty, like where we
Mm,
are now, not just in India but worldwide. He says
mm,
judges sometimes resolve this uncertainty by making a question smaller, right?
mm,
By narrowing the spaces like they did by defining institutional spaces, narrowing the class of animals, narrowing
mm,
the framework of inquiry, rather than by stepping back and asking the larger constitutional questions that the
correct.
case actually poses about Article 142, about the powers of
Mm,
the court, about judicial, ambition itself.
yeah.
So yeah,
Understood.
that's where we are right now. To be
Understood. Thank you so much for laying down all these four orders and for really synthesizing them. And some points that really stuck with me was the fact that at some point the court also has to realize that there is a chilling effect, and the way they write their judgments versus the way it's perceived in public and politics will be different. And then it becomes a loop where political pressure and public outcry then shapes the way the court writes its judgments.
Yeah,
And now what has happened is that the May 19th judgment, it's much more layered than what a lot of headlines suggest.
of course.
And what I want to do is do a granular breakdown of all these components that you talked about.
Yeah,
So the first layer that I wanted to discuss was the dismissal applications. So there was an application made for dismissal of the November 7th order, and the court upheld the November order, which included the mandatory removal of stray dogs and a prohibition of re-release, like you mentioned. The argument was that Rule 11, Sub Rule 19 of the ABC rules
Yeah,
um, would be violated if the November 7 order is continued.
yeah,
The response of the court, which you also mentioned, was interesting. They essentially said that, look, we've got Article 142,
yeah,
and if we do a purposive reading of the PCA Act, it allows us to exclude institutional areas from the operational of Rule 11, Sub Rule 19.
correct.
How do you evaluate this reasoning and particularly the use of 142 in this case?
Right. So I think, Arnav, the right place to start with the May 19th reasoning is to be very precise about what the court is doing and what it is not doing. Because the
Okay.
court also takes some pain to distinguish between the two, right?
Hmm.
But the court explicitly says, and this is important, is
Hmm.
that it is not striking down Rule 1190.
Yeah.
It is not declaring the ABC rules ultra vires. While
Hmm.
this is exactly what we wanted, we were very clear in our ask. We said that if you think that this is ultra vires, declare it ultra vires.
Correct.
Otherwise what you are doing is absolutely beyond the framework of this constitution.
Yeah.
So it is not even saying that rules are bad in law. What
Hmm.
it rather says, and I want to highlight paragraph 58
Hmm.
and onwards in the judgment.
Hmm.
What the court is really saying is that Rule 1119 cannot be read in the way that compels re-release into institutional spaces.
Hmm.
So it is basically not reading the clause 19 of Rule 11 in a in its literal sense.
Hmm.
It is giving it a special meaning. So it is
Yeah.
saying that schools, hospitals, transport hubs are all basically exceptions, and you cannot re-release these dogs into, while Rule 11 clause 19 is very clear, it does not make this intelligibility
Any
clear,
distinction. Correct.
right? And Article 142 basically permits the court to tailor the application of the rule for those
Hmm.
specific spaces. I mean, it has pages and pages together justifying the use of Article
Yes.
142,
Yes.
right? So the move is presented not as overriding the statute, but as purposive narrowing down of it.
Hmm.
The court, as I said, roots this in the standard laid down in Article 142. Now, give me 2 or 3 minutes to explain
Yeah.
the jurisprudence of Article 140. Although I'm not
Hmm.
a constitutional law professor, but I had to kind of literally
Yeah.
dig up all of these, case laws and whatnot to understand what the court is really trying to say, because
Hmm.
it applies to us as well.
Yeah.
So when it comes to Article 142, you directly kind of go back to Union Carbide case
Hmm.
and the Supreme Court Bar Association case, and most importantly, the Shilpa Shailesh case, where the Constitutional Bench recently in 2023
Hmm.
talks about irretrievable breakdown.
Yeah.
Now, Shilpa Shailesh gives the court the test it relies on, which only which places limits on Article 142, and those limits are what the Constitutional Bench calls in Shilpa Shailesh general public policy,
Hmm.
which would include fundamental rights, secularism, federalism, etc., and specific public policy.
Hmm.
Express preeminent prohibitions in substantive statutes.
Yeah.
And then the court says that, using this logic, the court says that the ABC rules do not embody specific public policy of this kind that
Yeah.
fetters Article 142. So we can
Hmm.
carve out institutional areas using Article.
Hmm.
Now, here's where I think the reasoning is genuinely contestable,
Yeah.
and where the impleadment that we did
Hmm.
was filed, which makes a very sharp argument that the court engages with in this judgment, but does not fully meet that criteria.
Yeah.
Let me explain this. The PCA Act and the ABC rules under it, the umbrella act is the PCA Act 1970, the Prevention of Cruelty to Animals Act.
Yeah.
And ABC rules of 2023 is a delegated legislation under it.
Hmm.
Are not any other free floating subordinate legislation. They are
Correct.
the statutory machinery through which two articles of the Indian Constitution is effectuated. Article
Correct.
48 and Article 51 each. Article 40
Correct.
directs the state to take steps for organizing agriculture and animal husbandry on modern and scientific lines and to prohibit slaughter of cows and other milch cattle. We have
Hmm.
seen the use and misuse of this to, enact really stringent beef ban laws in this country.
Yeah.
And Article 51 AG, which imposes a fundamental duty on every citizen to have compassion for living creatures. This is a
Yes.
fundamental duty. Of course, it is not justice.
Hmm.
Now, the Supreme Court in Mirzapur Moti Qureshi
Hmm.
and again in the 2014 Nagaraj judgment said that these provisions taken together,
Hmm.
provisions of the Prevention of Cruelty to Animals Act, read with 51 AG, give animal welfare a recognized constitutional status. In
Correct.
fact, it says that in Nagaraj 2014, it says that Section 11, read with 51 AG, is
Hmm.
the Magna Carta of animal rights in India. Now,
Hmm.
I fail to understand how there could be a Magna Carta that is given to that gives rights to a certain category of people, and I am considering animals as people,
Yeah.
and then take it away after a few years in 20. So that's another
Absolutely.
story for another day.
Yeah.
In the May 19 judgment says ABC rules do not reflect specific public policy worth deferring to under Silpa Salish test. I
Hmm.
think it is what it is doing is it is underplaying the court's own prior categorization or
Hmm.
characterization of those very rules and statutes they sit under. Now,
Yeah.
these rules are not procedural rules. As I said, they are not any other delegated legislation.
Hmm.
They are operational expressions of these two constitutional commitments, and the
Yes.
Shilpa Sailesh test, properly applied, should treat them as such. You are basically underplaying the PCA Act and the ABC rules.
Yeah.
And on top of this, I want to kind of highlight through this platform that there is a deeper point here.
Hmm.
Now, Raisa Vakil makes a very lucid kind of an argument
Hmm.
that Article 142 over decades developed without internal guidelines.
Yeah.
What she calls as a residuary jurisdiction that the court invokes without consistently articulating when it will defer to legislation and when it will not, as
Yeah.
if it is the whims and fancies of the court. And the worry is precisely this, that if Article 142 can be used to tailor a statute every time the court, let's say, is convinced of an urgent purpose,
Yes.
then statutes become provisional documents. They
Hmm.
have no certainty and solidity at all.
Hmm.
They are operative, until a sufficiently moved bench that is shocked by something like, the news article that it read and took so much cognizance of. Fine,
Hmm.
if they find it inadequate or if they find it to be sufficiently moving, they just decide to invoke Article 140.
Yeah.
Right. So what we argued is that, and I think it still holds. It's not like that our argument was dismissed in
Hmm.
the. I've read it very carefully. It's a 130-page judgment, so it took time to read and read it. I think it's still the argument that we made is it still holds is that the proper course in such a situation is for the court to either interpret Rule 11 Clause 19
Yeah.
within its own terms or to strike it down, and that is exactly what we want. You strike it
Yeah.
down. If you think it is ultra vires, the constitution.
Correct.
What it should not do is leave the rule in force while issuing directions that contradict it.
Hmm.
Literally contradicts it for a specified class of spaces.
Yeah.
Is then you have a very strange situation which we are in right now. That the same rule simultaneously commands and forbids the same conduct
Hmm.
depending on which side of the gate the dog happens to be on,
Yeah.
whether it is my dog inside this, let's say, house of mine, or
Hmm.
it is a dog on the street, which is supposed to be a community dog, which
Yeah.
side of the gate the dog happens to be. This makes me really think if the rule of law
Hmm.
in this country has any structure to it or not. or is it subject to the moods of the courts
Yeah.
sitting in the Supreme Court or the High Court? Uh,
Yeah, I mean,
yeah,
the whole question of having certainty becomes becomes a myth because you can use and deploy Article 142 in ways that devalue a provision that first you said has constitutional status and is is made in furtherance of a constitutional obligation.
yeah.
So, I mean, that's one of the biggest uh, structural issues and incoherency, I would say, in the entire judgment. If you try to
Absolutely. I mean, one of the phrases that is commonly used in our circles is that a court's judgment in today's day and age in India is as good as the breakfast he had in the or she had in the morning, right? And exactly what is happening today.
yeah, understood. And now let's move to the second layer, which is the euthanasia direction. This is direction H in the judgment. Now we know that the word may is permissive, it's not mandatory. So euthanasia is one of the legally permissible measures amongst others, and there are certain conditions attached. The first condition is a due assessment by some veterinary expert. There must be strict compliance with the PCA rules, ABC rules, and other applicable protocols. And then the dogs covered are must be rabid, incurably ill, or demonstrably dangerous and aggressive. So this is a narrow class subject to expert determination as per existing law. And yet, just within 2 days of this judgment, the Punjab Chief Minister Bhagwat Mann allegedly tweeted that the court had given a free hand to kill all stray dogs
Yeah.
and announced statewide elimination campaign. What
Yeah.
do you think is the practical impact of this euthanasia direction?
I got to know about this tweet
Yeah.
after I had already kind of watched videos and pictures of, and this is kind of disturbing,
Yeah.
of dogs being picked up by their hind leg and smashed on the wall in I think in Khalsa University or somewhere in Punjab,
Hmm.
which was like this. It ruined the whole week for me. Like I could not. It's very difficult to when you watch something like that. It's very difficult to go on in your day.
Yeah, of course.
Right. So now the text of direction H, as you were pointing out, is
Hmm.
very narrowly framed. That's true. The word that they are using is may. The conditions are very layered, as you said. Veterinary assessment, compliance with PCA, ABC rules, protocols, everything is being mentioned in the direction.
Yeah.
And the category is very restricted to rabid, as you said, incurably ill, demonstrably dangerous, and aggressive dogs, which is a
Yeah.
very subjective kind of an assessment, but
Correct.
we'll get to that later.
Yeah.
So, if you read direction H in isolation, it is doing what existing law already permitted. If you look at section 13 of the PCA Act, it allows for euthanasia under defined conditions.
Hmm.
Right. Rule
Hmm.
11 of the ABC rules also provides for it. So at the textual level, direction H is almost descriptive of what already exists in the law. But
Hmm.
when the court is the spokesperson, when the court is saying it, it has a very different kind of a chilling effect. Here is
Hmm.
the problem. Uh, we tried very hard to bring to the court's attention through our intervention and our impleadment, annexure R15 and R16 to be specific, and I can share it with you after this
Yes.
call is over. We placed before the court documented tables of public cruelty incidents after the August 11 order and again
Hmm.
after the November 7 order. There were beatings, poisoning, displacement of community dogs, and this is a pattern in both cases. And the moment a judicial direction is issued that even appears to authorize harsh measures against dogs, suddenly we see the public discourse and in some cases the conduct of even local authorities, which is not
Yeah.
uncommon. You will see that in a country like India, there are central laws like PCA saying that you cannot like relocate dogs, you cannot kill dogs, and all other things, and still have municipal laws in places like Bombay where you know
Yeah.
there are laws that are being made that are ultra vires the central legislature.
PCA. Correct.
So at the level of the textual law also this is happening, but when the court says
Mm.
the same thing, basically people start running ahead of the text.
Yeah.
And in the case of Bhagwant Maan, uh,
Mm.
which you were referring to, it's a textbook example of people running ahead of the text.
Yeah.
Text said May, he read it as free hand to kill stray dogs and statewide elimination.
Yeah.
And when the chief minister says this, then of course it would lead to disastrous effects.
Absolutely.
So if the campaign proceeds, anyone affected by it can challenge it precisely on the basis of direction H, which
Mm.
does not authorize mass elimination. But you tell me, how many people have the power to litigate in this country?
Absolutely.
Right?
Absolutely, no one would be able to do it. And the widespread nature of the effect of this direction will be such that it would possibly be impossible for you to point out and place liability on any one person, which of
Exactly.
course the court protects ultimately in
Exactly. So we will have to look at what uh, the language that the court is using has some
yeah.
on ground implication. There is a very interesting concept that is useful here. One of my favorite, social scientist, the French sociologist Bordeaux,
Hmm.
uh, you know, talks about what is called as symbolic authority. The
Hmm.
idea that when an institution as authoritative as the Supreme Court, which is like
Hmm.
we call it the temple of justice, right?
Yeah.
The social meaning of its word is determined not only by what the words formally say,
Yeah.
but by what they license in the minds of those who hear them.
Hmm.
A direction that says may narrowly with conditions is heard by the aggrieved municipal officer who is frustrated by these dog bites, or
Hmm.
even a frightened parent, for example, which I don't
Yeah.
blame them, right?
Yeah.
Or even an opportunistic politician like Bhagwan has a green
Hmm.
signal to do all kinds of brutalities.
Correct.
This is what Bordeaux calls as symbolic,
Yeah.
right? So when the court drafted this direction, I think the question that I want to ask is, I mean, or I want to say that it was insufficiently considered as to what the implications or what kind of effect it would have.
Yeah.
And what we should have asked is, what does this direction do in the real world? Given the
Hmm.
documented pattern of misuse of these kind of directions, and we literally at ALC documented all of this and showed to the court, but they turned an Nelson eye towards all of this. So, what do we do?
Yeah. I mean, it's a sad picture. And the one thing that I wanted to say was that for anyone who has experienced a dog bite or these deaths that are happening, the argument is not that these do not exist or we should undervalue them, but
Yeah,
the point is that these are symptoms of a larger problem within and a larger structural problem that must be addressed.
yeah,
And possibly the only direction that this judgment goes towards treating the cause and not just the symptoms,
yeah,
was the ABC Center's direction, saying that
absolutely.
every district must establish fully operational animal birth control center, have infrastructure, have person trained. The question that I have is that how credible is it? Because you we know most of our municipal bodies in India cannot meet their normal revenue expenditures through internal sources. Against that backdrop in the reality of Indian municipal bodies, how do you read this specific direction?
Absolutely agree with you. I mean, I agree that the only direction in the judgment that actually addresses the cause rather than symptom, as you put it,
Yeah.
I cannot agree more with you on this. Uh,
Hmm.
we all know that sterilization works. The science is unambiguous on this. A
Hmm.
sterilized, vaccinated territorial dog population
Yeah.
is smaller, more stable, and less likely to bite than an unsterilized one.
Hmm.
I am yet to come across a scientific study that says otherwise.
Hmm.
So, a direction that mandates an ABC center in every district with surgical facilities, trained personnel, etc., this is something to celebrate, right?
Yeah.
But Arnav, the irony of the situation is that this is not the first time the court has, said
Mm,
something like this. The
mm,
question is a very different question that we must ask. It
yeah.
is exactly what you were saying. It is the question of credibility.
Mm,
And our impleadment placed something very specific before the court with regards to this
mm,
credibility question. There is a Reserve Bank of India report on municipal finances of 2024.
mhm,
The report says something very, very shocking. It
mhm.
records that most municipal bodies in India are unable to meet even their revenue expenditure from their own sources.
Yeah.
It's not a dog question. It's
Yeah.
not a monkey question. It is a report card on all municipal, corporations and all
Yeah.
municipal bodies. They depend on irregular transfers from state governments.
Mm,
They are not, in the language of the report, financially autonomous bodies,
mm,
constantly running just to stand still.
yeah.
Okay? So when we then place this arithmetic before the court, which I think is worth repeating, right? What we were
Mm,
basically saying is that roughly 15 lakh educational institutions, according to the economic survey, has around an estimated population of around 5.25 crores.
yeah.
And if you do a conservative estimate of 10 dogs per education institution, NALSAR has around 20.
Yeah.
You are looking at over 1.5 crore dogs that would need to be sheltered if the institutional removal direction were fully implemented.
Yeah.
One, this is 1.5 crore dogs that we are talking about at the capacity of 200 dogs per facility, which is in itself cruel, right?
Yeah.
200 dogs per facility is overcrowded shelter,
Mm,
right? Uh, this means that we need over 77,000 new shelters just to house these dogs that are relocated from education institutions.
mm,
Just to accommodate these dogs, we need
yeah.
77,000 new shelters. Leave aside hospitals and transport hubs, it would run into lakhs. Right?
Correct.
Now, the May 19 direction does not ask for 77,000 shelters in one shot. It
Mm,
takes a more practical route. It asks for a functional ABC center per district. That's around
mm,
750 centers. Much
mm,
more modest. But two things follow from it. First, even 750 functional ABC centers, properly staffed with all the surgical capacity and post operative care,
mm,
requires capital expenditure on a scale that I am sure, if when I read the RBI report, I am sure
mm,
municipal bodies cannot currently raise.
yeah.
Without a fiscal devolution mechanism, without a financial commission grant, without, and this is important, without a centrally sponsored scheme. I
Yeah.
have not heard the Prime Minister speak about dogs even a single time,
Mm,
right? A centrally sponsored scheme, the direction operates in a vacuum. The court is not going to fundraise for this, right? The court may
absolutely.
monitor, but who is going to, where is the money coming from? So,
Yeah.
and the second very important thing is that the relationship between ABC Center's direction and the removal direction is asymmetric in varying ways. Right?
Mm,
Removal direction is enforceable today on
mm,
the ground. The ABC Center direction is aspirational. ऐसे मतलब one fine day overnight you will not have one ABC center per district. No, it is
correct.
aspirational, and its compliance has been delegated to high courts to monitor.
Yeah.
So the symptom management that you were talking about
Yeah.
is operationalized immediately. The cause management is deferred to monitoring framework, which we
Correct.
which we all know how overworked our courts are.
Yeah.
We all know how much pendency we have in the court. Which high court will have the time to hear all of this? So
Absolutely.
again, reminds me of Lon Fuller.
Mm,
Fuller kind of wrote about what he called as morality of
mm,
the conditions under which a legal order is at least even minimally legitimate.
yeah.
One of those conditions is the law, should not be such that it requires impossible conduct.
Mm,
A direction that mandates infrastructure that no level of government has the resource to.
yeah.
If you ask Fuller, he would be turning in his grave. A direction that fails one of the basic tests of legality, it will look like a law, it will have all the gestures of a law, but it cannot be obeyed. And if you read Bordeaux and Fuller together, then what is the message in terms of language? Because Bordeaux talks
Yeah.
about language. What is the messaging that is going out for a law that is established that can never be obeyed? If a law cannot be obeyed, what fills the gap is not implementation ever. It
Hmm.
is, uh, it is basically improvisation, what we call as jugaad,
You got it. Yeah.
right? It is improvisation that will fill the gap. And
Hmm.
unfortunately, jugaad may have a positive connotation to it in India for in many contexts. But when
Hmm.
it comes to dogs and animals, it historically has meant culling of animals.
Yeah.
Indiscriminate culling and killing of animals is what jugaad means in India, right?
Yeah.
So the ABC centers direction as a matter of principle is at the heart of the judgment. I agree with you. I cannot agree more. But
Yeah.
operational design wise, it is a part of the judgment that I'm least confident will actually come into being. Since, as
Absolutely.
I said, since the 90s, there have been many such orders from this.
And what I feel is that that direction is mostly rhetoric.
Yeah,
It's just a cover up saying that, oh, because we've now said that immediate removal of dogs, there'll be some section of people of the society who would be enraged by this. So let's throw them this ball and say that, oh no, we'll also have these centers, while the practical reality and the numbers themselves show that this is far from what can be achieved in India for like a sustained period of time as well.
totally, totally. Just like there is the facade of democracy in this country, there is also a facade of rule of law that needs to be maintained.
Yeah, understood. Now let's move to the more I would say hopeful part of the judgment, which is the NALSAR exception. And the judgment specifically permits the Animal Law Center at NALSAR to continue operating the CSVR, or the Capture, Sterilize, Vaccinate, and Release model inside of the campus on experimental basis, subject to filing an undertaking with the Vice Chancellor that you accept tortious liability for any dog bite incident that happens. How did this come about? Can you talk more about this experiment? How does it look like in practice on our campus?
Okay, so this is the part of the judgment which I have to acknowledge is a kind of a. I have to take a dual position on this
Okay.
because I am simultaneously a critic of the judgment and a
Hmm.
beneficiary of one of its provisions.
Yeah.
Right? So let me try to be honest about both.
Hmm.
The provenance of the exception is something I want to walk through very carefully because, as I said, this affects my center and it affects the way the ALC has built some kind of a reputation over the last decade.
Yeah.
I think it tells you something about how this particular intervention really worked and why
Hmm.
it worked.
Hmm.
Let me give you some. I don't need to give it to you, but for the audience, because you're
Yeah.
from NALSAR, you would know. The Animal Law Center was set up in 20. It was set up actually in 2016, but it became functional in 2018.
Hmm.
Uh, its work from the beginning was always research driven,
Hmm.
and there have been instances in the past where this dogs and monkeys have been politicized in student body elections, etc. And one of the most or the first level of defense that I would have is that we are just a research center. We are
Yeah.
not a governing body, right? We are not.
Hmm.
That is the admin. That is for the administration. We have been research driven, building a body of scholarship on animal laws. We've also
Yeah.
been training students wherever we can.
Hmm.
We engage with statutory bodies, train a lot of judges, a lot of uh, the executive part of of the governance structure.
Yeah.
But alongside the academic work, what evolved at NALSAR over a better part of a decade
Hmm.
is a very quiet on ground demonstration that a 55-acre campus with a stable, sterilized, vaccinated community dog population, which is monitored through a census, which we did way back in 2020 or 2021,
Yeah.
fed at designated points and embedded within the culture of students and faculty
Yeah.
participation, could function as a safe, peaceful space for humans. It's not.
Peaceful coexistence. That's the name of the game for us.
That's the name of the game. It's very familiar to you and I, right?
Yeah.
And this is something that we keep reinforcing at NALSAR.
Yeah.
So numbers, and these numbers were placed before the court in annexure, I think, R19
Mhm.
of our impleadment, shows a remarkably stable story. We have 19 resident dogs in a 55-acre campus, roughly one dog for every 3 acres. 3 acres is a huge area, right?
Yeah.
Almost all are sterilized, vaccinated, air chipped. We have a list of photographs and health records maintained in a database, has been
Yeah.
circulated in the student body. There has been no documented unprovoked bite incident attributable to campus residents
Mm.
in the recent history, and therefore the model works and it has worked for years.
Mm.
Now, when the November 7 order came,
Mm.
it became clear that the framework being constructed by the court would, if applied to NALSAR without modification,
Yeah.
dismantle the whole, like all of the hard work that we did in the past 7, 8, 10
Mm.
years. And exactly the kind of working arrangement that the court itself was lamenting the absence of. We had it right,
Yeah.
b- below its nose. We had this example.
Mm.
So we approached the court through an impleadment drafted by I think it was drafted by Gautam Bhatia and argued by K.K. Venugopal, and
Mm.
who was the former Attorney General, who
Yeah.
was very generous with his time on this. He's one of the most senior lawyers in this. And the
Mm.
submissions were very specific. It was not that NALSAR is special. That is
Yeah.
what we are trying to say here. It was that NALSAR is replicable. That what
Mm.
is being done on our campus could be done in other campuses with institutional commitment, of course. And I'm super grateful to the leadership at NALSAR for the institutional commitment. The
Yeah.
previous administration and this, the previous administration allowed institutional feeding that really kind of helped us, and
Mm.
this one has done enough and more for us, and also allowed us to approach the court and you know
Yeah.
protect our own dogs. So institutional commitments, the sterilization protocols, and most importantly,
Mm.
student participation,
Yeah.
with of course administrative oversight, but student, it is and will always be a student driven initiative,
Yeah.
right? So when we placed before the court the UGC, let's say, notification of 2025, the directive that
Mm.
already encourage all higher education institutions to set up animal welfare societies,
Yeah.
and a collation of statements from schools and universities across India that had publicly committed to human campus management,
Mm.
and the database, what we were placing before the court is a ready-made policy.
Yeah.
Also, by the way, there is also a long 20-page policy that we started drafting in 2020. We did a
Mm.
survey. This was part of the 1 year long animal law clinic. Some of our students worked on the survey. We used the survey and its finding and analysis to basically draft the policy in 2021, 2022.
Yeah.
The court's response to this,
Mm.
paragraph 73, was more measured than I had expected.
Mm.
The court records in its own words, and I think this should be the highlight, this should be the takeaway from this whole interview.
Mm.
The court records that fervent arguments were raised on behalf of NALSAR, and that we had institutionalized human treatment of stray dogs. By we, I
Mm.
mean we at NALSAR.
Yeah.
And that similar social experiments could be undertaken in other educational institutions, which would
Mm.
act in furtherance of the spirit of the ABC Rules 2023. Emphasize the inculcation of empathy among students. The NEP also kind of does the same.
Yeah.
Emphasize the inculcation of empathy among students and inspire them to be kind to animals in both letter and spirit of the statutory regime,
Yeah.
right? The court grants this exception, permits the CSVR program to continue in campus, but of course with conditions
Mm.
that we will, submit an undertaking to the VC, etc. In practice, what it means for NALSAR is the following: is
Mm.
that existing model will continue, dogs will stay, the students will continue to be involved.
Mm.
everything will stay as it is, but of course we'll have to document it, which we have been documenting all this while, and maybe
Yeah.
also show it to the court that this is replicable,
Hmm.
right? So in effect, the institute we become an institutional party that the court can hold accountable if something goes wrong, right? And
Yeah.
that of course we are here to take that burden, and we
Yeah.
are presenting it. It is a price of being allowed to continue doing what we were.
Absolutely.
It will require all of us, students, teachers, most importantly students, teachers, staff at NALSAR, to come to the negotiating table and agree on how we define liability.
Yeah.
And I, for one, have never shied away from a difficult conversation. I have full faith in our students and in our administration. And I think there is only good things ahead of us.
Absolutely. And I think the main takeaway for me, for like the broader picture, was that this model that we have on campus is not so complicated that it can't be transposed to other institutional campuses.
Yeah.
It's very simple, and all it takes is just a few um, motivated people, and you just start, and everyone gets on the bandwagon and does it ultimately. And what I was expecting generally from the judgment was that instead of the animal centers direction, which practically is impossible, you have this sort of a direction saying that all institutions need to have this sort of a CSVR model implemented.
Mm.
And I mean, this could be a widespread model that is adopted hopefully in the future by different
Arnav, the
institutions.
court does kind of, allow other institutions to
Mhm.
already do this with the condition that they submit a similar undertaking to the
Yeah.
head of the institution. So it's not
Understood.
like it disallows other institutions. It's not like the exception is literally for nuts.
Yeah. Okay. Understood. So now what I want to do is close with just a very short question about the future of animal rights and animal welfare law in India. If we think about the framing of this case, from the very start, it's been heavily anthropocentric. Even the title of the case is very anthropocentric. It's basically that if animal welfare and human safety are two values, and if these are competing, then human safety will win all the time,
Yeah.
right? And it forecloses any possibility of what we call as a peaceful coexistence. So my question is this: what do you think is a realistic path for animal welfare law in India, and how what can be done to change this sort of an anthropocentric framing?
No, okay. So before I answer that, I think one very important point that I want to make is how do we see the court? What is the
Yeah.
citizen's gaze that is expected out of a citizen towards the court?
Yeah.
And I'm saying this uh, because they invoked Article 142, and
Mm.
also, like, again, Raisa Vakil, who I was referring to, says
Yeah.
that, I mean, if you read Article 32, 136, 142, it vests. Um, I mean, the role of the court is much wider than dispute settlement, and we have
Yes.
seen that during the emergency. We have seen that in the works of Justice Bhagwati, Justice Krishna Iyer, etc.
Mm.
And then Sham Devan also calls it the institution of governance. So we really
Mm.
still look up to the court, right? It
Yeah.
is not merely a constitutional or appellate court. It is a polycentric, what Shamdevan calls as a polycentric problem solving exercise.
Mm.
The whole idea of a PIL, often with strong legislative flavors in terms of sweep policy content and reformative focus. So
Yeah.
if I have to, crystal gaze into the future, I first have to be very clear on how I want to, as a citizen of this country, perceive the court from.
Or- Yeah.
The people are going to hate the court for what it is saying. If you care about or are compassionate, or really uphold the value that 51 AG stands for,
Mm.
right? But I do think that the court still has a very important role to play in this,
Yeah.
and it of course there is a doctrinal angle to it. There is the Shilpa Sailesh union that is for the lawyers to look at,
Yeah.
and there is a procedural aspect to it, where if the court is saying that ABC centers have to be established,
Yeah.
That is for the executive to kind of figure out how to do it. Of
Hmm.
course, there is also, when I say that, I also want to kind of highlight that we were not heard properly. It's, of course, our privilege as somebody at
Hmm.
NALSAR to implead in the Supreme Court
Hmm.
and impleaded through KK Venugopal, right? It's
Yeah.
because we are
Yeah.
privileged. Not every
Yeah.
institution can do it, not every bus depot can do it. So
Yeah.
there is also a question of audi alteram partem.
Hmm.
These are gaps that needs to be addressed.
Hmm.
And unless we kind of, as citizens, unless we kind of uh, address or start having conversations about these gaps, about what the court should have done and what the court is really doing, I
Yeah.
don't think that it is fair to be absolutely dismissive of the court, come what.
Hmm. Yeah.
To directly answer your question in just like maybe 2 to 5 minutes
Yeah.
about future and crystal gazing,
Hmm.
this basically, this whole case reveals the underlying architecture of what is going on in this country. Like, if you begin with the May 19 judgment on its own terms, it is very direct about how it resolves the tensions that you were identifying. Like, Para 101 says, while, and I quote the quote, while
Hmm.
considerations pertaining to animal welfare and protection of sentient beings constitute matter of undeniable constitutional, statutory, and moral significance, such considerations cannot be permitted to eclipse or subordinate the paramount obligation of the state to safeguard human life, bodily integrity. So, human rights or human interest trumps animal rights or animal interest.
Yeah.
No doubt about it. That is what the court is saying. But the court is also still acknowledging animal welfare and
Hmm.
protection of, it does not say protection of property, animal property. It says protection of
Hmm.
sentient beings,
Hmm.
right? So the court does not deny animal welfare. The court does not deny sentience
Hmm.
and goes away in that sense from the property framing.
Yeah.
And then it, of course, tilts in one direction over the other.
Hmm.
So the first important thing about this observation is that we must bring back the narrative of Article 51 AG, the narrative
Yeah.
of 2014 Nagraj.
Hmm.
A large part of it, the whole of 2014 was not reversed by
Hmm.
Jallikattu, right?
Yeah.
I still, and a lot of us share this thought that it is like Article 51 AG and let's say Section 11 of PCA is still the Magna Carta of animals,
Hmm. Yeah.
right? So we need to go back to it. 2016 Mirzapur Moti, Gautam Bhatia says that the uh, that there are restrictions on fundamental rights, and when grounded in DPSP and fundamental duties, they you specifically are, and in this case 48 and 51 AG,
Hmm.
it would be presumed reasonable so long as they do not run into clear conflict with fundamental rights. Which is why I'm saying that these parts of the 2014 Nagra judgment still survive.
Hmm.
So May 19 judgment is rhetorically acknowledging this body of jurisprudence.
Yeah.
And then we are operationally kind of trying to bring this back in the public imagination of how to imagine the court, how to imagine the imagine animals, and how to
Yeah.
also give credit to equal credit to people who are doing what the state should have done. Feeders,
Hmm.
for example, are people who are feeding these animals while the state should be doing it. The
Correct.
state should be sterilizing, vaccinating, and putting them back in the same place,
Hmm.
and at the same time feeding them with the hope that scientifically, not just hope, but scientifically, the population will come down. But
Yeah.
until the population comes down, they have a responsibility towards this
Of
living.
course. Of course.
So this is how I want to kind of look at the future from uh, conceptually. Of course, we are, the key is basically coexistence, living with each other in a more safe way. Of course, safety is not to be
Yeah.
compromised ever. But I want to kind of uh, invoke Michael Serres here, who writes this really interesting book called The Natural Contract. I
Hmm.
mean, I'm really hopeless at this point in time, looking at the kind of wars that we are engaged
Yeah.
in, and so on and so forth. I feel that the social contract is broken, but
Hmm.
whenever something breaks, there is an opportunity for something new to be constructed. And
Hmm.
he writes this book called The Natural Contract. And
Hmm.
his argument is that the social contract, which is the foundational document by which political community organizes itself,
Hmm.
has for the entirety of Western political theory been, limited to humans, with the
Hmm.
non-human world appearing only as a either as a resource, a backdrop, or an object.
Yeah.
Except for that one place where they talk about sentience of animals in this judgment.
Hmm.
Everywhere else, these animals, wherever they are referred to, are referred to as objects,
Yeah.
as they are framed as animals that could be that could lead to lack of safety for humans.
Yeah. That menace is what
Yeah,
they
exactly.
constantly try to portray.
Use that word. So yeah. So so the absence of any engagement with the possibility of reciprocity is the
Hmm.
deepest absence in this reasoning. But then I only want to see some light in the at the end of the tunnel. So I am looking at the invocation of welfare, the invocation of sentience from this.
Understood. And I think that that's really important, especially to consider how we move forward from this judgment and what can be done to change just the framing of the way we have these conversations about animal welfare, about human safety in consonance with animal welfare. And I hope that this the institutional experiments and some of the other things that we've discussed in this interview help chart out this particular process. So,
Absolutely. No, I just want to come in here and say that, I mean, framing changes when conversations change.
yeah.
As long as we are talking about human safety versus animal welfare, we are
Hmm.
working inside a binary, and this binary is only constructed in our mind. It is not,
Yeah.
it's not real. It's just there. Like it's almost like man, woman,
Hmm.
good, evil, that kind of a Cartesian binary. Human, animal is that kind of a binary. So we need to
Hmm.
think beyond those kind of things.
Correct. Correct. And I think that that will really help in all the conversations and hopefully what the future will look like. So thank you so much for agreeing to come on this podcast, and it was brilliant talking to you.
Thank you so much, Arnav, for the opportunity. Bye. Have a nice evening.